Hi, my name is Jose Garcia, and I'll be talking to you all about the Standridge versus Union Pacific Railroad Company. So, the Union Pacific Railroad Company offered health insurance plans to all of its employees. These plans included doctor visits, shots, but it excluded contraceptives unless it was medically necessary. Now, Brandy Standridge and Kenya Phillips filed a lawsuit claiming gender discrimination under the Pregnancy Discrimination Act of 1978. They argued that it discriminated women by failing to cover contraceptives. The Pregnancy Discrimination Act states that employers cannot discriminate against anyone regarding compensations, terms, conditions, or privileges of employment because of gender. Also, women affected by pregnancy and childbirth must be treated equally. In this case, the court had to acknowledge the fact that Pregnancy Discrimination Act protects conditions after conception and not before. So, speaking into technical terms, contraceptives are to prevent pregnancy, not a medical treatment, so it would not fall under the Pregnancy Discrimination Act. In the ruling, it was also stated that since the insurances did not cover male contraceptives either, men were not treated more favorably than women. So, in the end, the ruling was that since the Pregnancy Discrimination Act does not require companies to include contraceptives in their health plans, companies may opt out of including them from their benefits. Now, in the ethical view of it, the question stands, should employers be required to provide contraception coverage in their health insurance plans? Now, the analysis that it provided an argument that not providing coverage for contraceptives is unfair to women as they have to deal with all the consequences of unplanned or unintended pregnancies. Now, the counter argument to that is that the effects of not providing contraceptives are not considered under the principle of least infringement. So, the courts should not be the ones to determine what health insurance coverage employers must get their employees. Now, if Congress wanted to make their employers provide contraceptives in their coverage, then the federal law should be amended to agree to this new ruling. Now, the second ethical issue is that comparable health should compare the preventative medical coverage provided to women and men. Now, Congress had originally passed the Pregnancy Discrimination Act to overrule a Supreme Court decision that allowed employers not to cover pregnancy in their short-term disability plans. Now, Congress found this discriminatory in employers providing health care for all of their health risks except for pregnancy. So, in theory, this is also discriminatory to provide health insurance for all of the risks, even pregnancy, but not for contraceptives that prevent the pregnancy. So it should be treated as all types of preventative care. Now, the counter argument to that is that if contraceptives are not provided for men, then they don't have to be provided for women, and that health insurances may treat men and women equal. Now, personally, I think that women should be allowed to have contraceptives included in their health insurance, as it is true they are the ones that have to deal with the pregnancy. Now, I also don't think that it's a good idea to compare men and women as they are different anatomically and they require different things. I also think that providing contraceptive could even lower the cost of coverage on pregnancies because if you provide contraceptives, it would lower the unintended pregnancies that could occur.